May for again 3 months.
Which is that order?
My lord, it has been passed after this filing of SLP.
Place it on record. Otherwise,
My
this
lord,
is
I
not
will
your-
do this during the course of day. You can consider it. I can pass.
No.
My lord, she
There
is
is
under
nothing
detention
otherwise.
since
Otherwise, there is
last
nothing.
9 months. She is not an habitual
If-
offender. No.
If there is such law in the state of Nagaland, that has to be complied with.
My lord, nothing is placed on record that there will be any threat to the state or she will indulge in the same activity again.
As of now, this petition has become infructuous. If you say there is an extension, please place that on record.
My lord, I will place.
That order is not there on record. How do we proceed?
My lord, it was passed only on 30th of May.
Therefore,
I will just do
place
it in
that
the
on
course
record.
of day.
Place it on. Post after 2 weeks. Yes.
Obliged.
My lord, may dispose of the matter. I am squarely.
Just 1 minute, just
Yes.
the order of detention has run its time. The counsel for the petitioner submits that by an order dated 30th May 2025, the period of detention has been extended for another period of 3 months. Let the said order be brought on record. Post after 2 weeks. Yes.
Unless
We have
I
permitted you to place it on record. Yes. Yes, Mr.
my lord, I appear for the petitions, my lord.
Yes, this is covered.
Yes, my lord.
Yes. Delay also
Delay.
200 days, 209 days. It's
All-
covered with this 8418.
Union of India versus Rajiv Gandhi.
Uh-huh. Yes, delay condone, issue notice, tag with so so.
My lord,
Oh, sorry, yes, please. Yes.
Please, ma'am.
Yes,
Now, in this matter, I am for the intervener. Now, the main petitioner in SLP, Mr. Pinaki is under serious health problem.
Who?
So, Mr. Pinaki, you are in the main SLP petitioner.
Pinaki Misra.
Not Pinaki, Mr. Shishir Pinaki. He is sick. So, kindly have a request to have it after vacation.
Yes, great. Post
Much
after period.
Much obliged.
Yes.
My lords, item number 7 is to be tagged with the larger batch.
Yes.
That is SLP 27736 of 23.
23382 also.
My lords, may just tag it with the larger batch.
Condone, issue notice, tag with SLP serial number 27736 of
23. My
Yes.
lords, same order in 45. Item 40.
Yes, 45.
My lord, if I may mention item at 7.14, my lord, I am appealing
Yes.
for the petitioner.
Yes.
My lord, in the similar case, in an earlier assessment year, in SLP 10636, notice has been issued. So we
Yes,
are
we have
praying
issued
for a
notice in
similar
all the
order in
matters.
this.
Notice issued in all the matters.
Obliged, my lord. Obliged.
Yes. Yes, condone similar matters.
May it please your lordship. Lord, the selected candidate was obviously disqualified. Lord, similar writ petition at the instance of another unselected has been entertained by the High Court. Lord, at page 124, if your lordship sees.
Of this very selection.
This very selection, Lord. But the High Court said I had no locus standi and dismissed it, Lord. That is the paragraph 16. May I read on? 124. That it is submitted one person so and so who also applied for the same retail outfit, filed civil miscellaneous so and so in the aforesaid petition issued notice.
You have not been selected.
I have not been selected, others have not been selected because the selected candidate was disqualified. This is a rural petrol bunk and the selected candidate should give a land in the rural area. He gave a land in the town area. He should have been disqualified. Well,
Yes.
Lord, when I pointed this out, Lord, all that I'm seeking is it should have been tagged along with the other writ petition rather than dismissed on the ground of locus standi. Locus standi will not arise.
Where is the other petition?
Lord, page number 124, paragraph 16 is the averment, but page 87 is the order in the other writ petition. You have page 87? That is the order in the other writ.
Concerning the same outlet.
Same outlet, same outlet. Lord, 3 candidates were disqualified. 3 candidates did not succeed. Another succeeded candidate, Lord, he was, we filed against him.
This petition is still pending.
Still pending, listed for hearing on the, Lord, it is listed, may I pass this on?
Then if his selection is set aside in this pending writ petition, you will also be benefited.
Lord, but the observations made by the High,
You may intervene in that.
no, the observations made by the High Court in the impugned order saying there is nothing wrong with the selection will, my Lord, be res judicata and the other matter. That is my anxiety.
Did you not inform the High Court?
Informed, and it was placed in the writ petition itself, the averment in the writ
The
petition.
outlet is not mentioned.
It is not, my Lord. He said locus standi, you have no locus standi, why should I consider other things? That was the court's reply. Lord, but I have not only stated, I have also filed this in my writ petition, page 124, paragraph 16, I have
But now
stated.
if we issue notice,
Yes.
the other petition will not be decided, saying that
Lord,
the
no,
same-
not at all. May I
same
suggest?
selection is under challenge before Supreme Court.
No, may I suggest this, my lord? If your lordship is pleased to issue a short dusty notice, when the respondent come, I'm going to say I'm not going to take any order from my lord other than tagging along. All that I'm seeking is tagging along. I don't want to delay the next matter. And the next matter is
Yes,
posted on
yes.
7th July.
The counsel for the petitioner submits that challenging the same
Selection.
selection of a retail outlet in favor of respondent number
5.
5. Writ petition C number 1891 of 2021 is pending before the High Court. However, the said aspect has not been noted in the impugned order, and petitioners request for tagging the present writ petition with the pending writ petition has not been considered, has not been dealt with in the impugned order. First of all, issue notice returnable in 8 weeks, justice permitted. Yes.
Lord, may I request 4 weeks, Lord, because if it comes before 4 weeks, I will be able to, Lord, tag along.
4 weeks is during PWD. 4 weeks, 4 weeks.
I'm obliged.
May I please, Your Lordship? As I'm seeking a passover in this matter, the arguing counsel is facing some technical difficulties in connecting.
Not before. We'll go to some other.
Okay.
Yes.
Obliged.
May I please, my lords, short post.
एक मिनट देखो ये जो एक सेल नंबर 18 है मैंने स्लिप दिया था स्लिप में लिखा था स्लिप ऊपर पेस्ट वो आया था क्या स्लिप में उसका नाम था हाँ उसको डिलीट कर दें
May I please, my lords,
Yes.
it's actually covered matter. My lords, this is a substantial question of law with regard to whether a woman's right, as under Section 14(1) of the Indian Succession Act, would ripen into an absolute right or not, my lord, is the question. My lord, this has been decided by this honorable court.
All 3 courts have decided against you.
No, but this honorable court has tagged the similar matter to a larger bench in view of the conflicting judgments by this honorable court, 3-judge judgment. But I just
Here, that is not the question here.
Yeah. no, I may submit just a moment.
Yes.
My lord, Section 14(1) or Section 14(2) would be applicable in my case. No? I'll take-
In every Hindu succession act matter,
Yes, ma'am.
where ladies' rights are involved,
Yes,
this question is always there.
yes, ma'am.
And any time you can argue that this matter is covered pending consideration before this court.
No. This honorable court, but just for a moment, ma'am. This honorable court has tagged this before has placed this matter before Honorable Chief Justice for constituting a larger bench for similar matter. My lords. Page months. I'll take my lordships the page book. My lords, page.
You know, when limited right was given,
Yes, my lords.
it was not before promulgation of Hindu Succession Act.
No, it was after.
It was
After. But
So if it is a limited right, it will limit it immediately.
no, my lords, the same question, my lords, by my lordships, my lords, in Tej Ban versus Ramkishan, which I've just passed over, my lords, the similar question has been placed before the Honorable Chief Justice because there are umpteen number of cases that have conflicting judgments between Tulsama versus Shesha Reddy. Yes, para 21, my lords, I'll start. Para 21 of Tej Ban versus Ramkishan case. Para 21, my lords, Malaj, we last 14 months, the decisive paragraph conclusion, Malaj. When he thus validly disposes his property by providing for a limited estate to the wife has to take.
Para 21 you are reading?
Para 21, subclause 14, Malaj.
Yes, this judgment is argued.
Just it's before para 22, Malaj, last paragraph, subclause.
So that is Tulsamma judgment.
Yes.
Hmm.
When when he thus validly disposes his property by providing for a limited estate to his heir, the
Para
wife.
14 you are reading?
Yes, subclass 14, para 22, just above para 22.
Yes, when he thus validly.
Yes, please, Naz. This restriction on right so provided is really respected by that. It provides in section 14.2 that in such a case the widow is bound by the limitation of so and so. In other words, the conferment of a limited estate which is otherwise valid in law is reinforced by this act by introduction of section 14.2. Even if that position is to be attracted in case of succession under the invocation of 14th subclause of the act, in case of a testament disposition taking effect after the act, would make sections 14.2 redundant or otherwise. It will also make redundant the expression property possessed by so. So, further, para 22. It is important to note that except in Karmi, the decisions by so-and-so are all by two judges or two judge benches. The larger perspective in section 14 was interpreted holistically, commencing from Karmi and which was followed by subsequent cases. Some of these decisions in the same line as Gaddam so-and-so and so-and-so. Para 23 minutes. We have noticed that while following Tulsamma, the subsequent decisions in Tota so-and-so and so-and-so made passing observations about the discordant note in the case of Karmi. But they have not been clearly categorically overruled. Perhaps this is the reason why subsequent decisions consistently followed the idea of Karmi and enunciated different principles in subsequent decisions so-and-so. Para 24. This I'm laying emphasis on this. We heard the present appeal in detail and also have taken a view in the matter. But having realized that there are a large number of decisions which are not only inconsistent with one another on the principle, but we have tried to negotiate a contrary view by distinguishing them on the facts or by simply including the binding decisions. We are of the view that there must be a clarity and certainty in the interpretation of section 14 of the Act. In view of the above, we direct the registry to place our order along with the appeal paper book before the Honorable Chief Justice for constituting an appropriate larger bench for reconciling the principles laid down in various judgments of this court and for restating the law on the interplay between section 40, subsection 1 and 2 of section 14 of the Hindu Succession Act. Here's the same similar case. I'll take my lordship's paper book of my paper book, my compilation. The short question of the law, which was decided by the learned single judge of the Amravati High Court, page 14.
It is about Schedule A property, item 4 only.
Yes, only one property.
Item 4
only. Item 4. And here, I'm in possession of the property through a gift deed given by my mother. My mother was given this property with a limited estate, which was ripened into a full estate after the after the death of the husband, death of my father. So, this is a case which squarely falls. Even in the similarity of the office note, recently,
this point was argued for the High Court.
No, because this judgment of the Tejban case was much prior to the judgment of the learned single judge. The learned single judge was subsequent to the Tejban case. So, the High Court did not have the opportunity to go through this judgment.
No, whether it was, there are earlier judgments also.
No, but this Tejban judgment was the latest judgment.
I have only referred to it.
No, referred to the larger bench in view of the inconsistencies of the judgment of Tulsamma. In Tulsamma case, honorable three-bench judge of this court.
Whether in the written statement also this ground was raised.
The written statement, I'll take my lordship.
I don't think it is raised. Because in none of the judgments,
No, written statement was filed long back. But Tejban case was just
the law will always be there. Interpretation of section 14, the interpretation which you are,
2024 minutes.
Yes.
This is a 30-year-old litigation.
yes.
This is 30-year-old. The
Whether you
Tejban
have
case.
taken this ground,
Well, I've taken a
that
ground.
her limited right,
Yes, page 9.
respect of item 4 property has
Yes.
ripened into absolute property.
Page 9 of my paper. Page 9.
9,
Yes, Manoj.
yes.
In the middle of the third paragraph, Manoj. Busureddy.
This was the question of law frame.
Yeah, just below that, Manoj, where my plea was noted down. Plus, for fourth line from the third paragraph. Busureddy bequeathed item number 1 of the plate issued property in favor of his wife, Durgamba, by giving absolute rights, and further items 2 and 4 of the plate issued properties were given to his wife with limited rights of enjoyment, and after the death of the third defendant, items number 4 of the plate shall be devolved upon the second plaintiff without any right of alienation to the third. It is a specific case of the appellant that the vested remainder rights in item number 4 of the plate issued property was given by second plaintiff.
Yes. We'll listen notice.
My position will be protected. I'm in position since last 30 years. At least status quo.
We'll hear the other side on.
At least status quo. My only their only submission is
Status quo and position protected is one and the same thing.
my only.
Merely because you use a different language, that doesn't change the.
I'm a poor farmer, rustic farmer.
Oh, you are pure farmer. Yes, we know. It is argued that the substantial question of law framed by the High Court, as reflected in paragraph 14 of the impugned judgment, is under consideration before this court to be decided by a larger bench, as the same has been referred to a larger bench in Tejban versus Ram Kishan, civil appeal number 6557 of 22, by order dated 9th December 2024. Para. Issue notice returnable in 6 weeks.
Status quo until the next adjournment. Only one plea, Manoj.
The prayer for interim relief shall be considered after notice.
Much.
Yes.
Much.
May I please, Your Lordships?
Yes.
Yes. My lords, in this case, the Honorable Tribunal has mistook it as a case of classification, whereas what the case of the department in the show cause notice is that because the importer has taken the benefit of the notification, my lords may just come to page 62 where the entry is there, that entry gives exemption to pulse.
So
the case of the department.
It was waste material.
Yeah, absolutely. It is not a pulse. Just have a look at that entry at page 62, the exemption which has been claimed. Page 62.
No, it is not about exemption, it is about entry.
No, my lords, it is a case of exemption. Just come to page 568, show cause notice, Your Lordships.
Para 11, you are, item 11, you are.
Absolutely, Your Lordship.
Yes.
Item 11, just come to page 568.
Item 11 is about classification of the goods.
No,
Whether
my
it
lords,
is 0713 or 2302.
no, my lords. The issue is, if it is under 73, the importer would be eligible to claim benefit of notification subject to the condition that it falls within the description of pulse.
Yes.
Otherwise, it will fall under 23. So the case of the department is, it is not a pulse. Just have a look at page 568, Your Lordship. Show cause notice.
Page?
568. Show cause notice starts from page 565, para 4 at 568.
Five, 6, 8, para 4, yes.
The tariff item so and so covers only dried leguminous vegetables shelled, whether or not skinned or split. The serial number 20 extended exemption to pulses chickpeas. The serial number 21 to extended exemption to pulses except chickpeas and lentils. The serial 21 is so and so so and so. Thus, only pulses, chickpeas, and lentils covered under 0713 were exempted under the above entries, whereas bhusi, which is outer layer skin of pulses, the exemption under serial number 21 of notification 12 was not available to the same. And just now have a look at the entry, Your Lordship, page 62.
Page?
So what? what the importer is claiming is exemption under this serial number 21,
Page
which is
52.
page 62, 62,
62.
serial number 21. 0713, exemption is to pulses. Now, can this skin of the lentils and other things can be treated as pulses, Your Lordship? That exemption is not at all available. This is not even been considered by the tribunal.
Yes. Late enable in 8 weeks.
A delay may be condoned, Your Lordship, 90 days.
Public.
12 letters.
Letter has been circulated.
Yes.
Public.
As per the letter, whatever time is paid for.
This is a
PWD request in terms of the real or adjournment made in the letter. Post after PWD. Yes.
this is a section 13 matter. I'm for the wife. Whereas in this matter, the learned trial court has granted a decree in favor of the husband.
Current.
Yes,
Your appeal is also dismissed.
Yes, Your Lordship,
What do you want?
my submission is the order of the High Court, 15
5 lakhs as permanent eliminate.
That's it, That's it, I am unemployed, uneducated.
You want divorce or you don't want?
My instructions are that we want divorce as well. Your Lordship, may I kindly consider the points that the High Court has raised.
Shall we issue notice on the question of eliminate?
Both I would request, Your Lordship, may just consider my submissions, What has happened is,
Notice.
my request is, the decree may be stayed, because, there is already a 494, may consider, there is already a 494 that has been filed against the husband, the High
So that is already over.
No, this is pending before the High Court.
494 is over. Means the fact constituting 494
Yes,
is already achieved.
What?
There was what for the stay now?
Before
He
the
is
High
already married according to you. If we have initiated 494,
Yes,
he is already married.
yes.
The stay is granted only for the reason that he shall not marry in between.
My submission
Now
is
he is already married.
on these submissions, even before the High Court, there was a stay until the pendency of the High Court proceedings, Now and before Your Lordship,
But he is still married.
my submission
He
is,
married after this impeachment or during pendency of the matter in the High Court?
he was married in 2007,
Oh,
and subsequently,
not a stay. What
my-
fact is a stay?
my submission is,
No,
his
we are not
case is,
granting. Next.
his case is, that he's not
Next.
deeply.
No case first. Yes. Good explanation. No case first. Yes.
Item 14 was led by someone, but not appearing on the screen. Not appearing on the screen, I was led by someone. Milords, I was submitting in this case, it's a case. Yes, Milords, where.
You want to argue or?
Yes, I would argue, Milords.
Lordship, may I submit?
There, she's on the screen.
Lordship, my suit for declaration and permanent injunction has been dismissed under Order 17, Rule 3, Lordship. I
Yes.
see an opportunity for leading evidence, Lordship. My evidence was closed by order, Lordship.
Yes, you didn't read the evidence, and then for that, all the courts have dismissed your plea.
Lordship,
You don't read the evidence.
Since
What else
Lordship,
court can do?
Lordship, the plaintiff had appeared, his examination in chief was tendered. The defendant counsel had sought time for cross-examination. He was asked to bring some documents. And Lordship, on 2 dates, the bar was on strike. The evidence could not be laid. He was available, Lordship. It is only, Lordship.
Several opportunities were given, you did not produce your evidence. That is what the trial proves. Despite opportunities, you did not bring the evidence.
Lordship, in fact, the documentary evidence was to be brought.
There is nothing, madam.
Lordship, Lordship, this will operate as res judicata against me.
It has to operate. 17.3 is meant to be operated as res judicata.
Lordship,
17.3 means merit. The decree is on merit.
I pray for one single opportunity, Lordship.
No. Yes, nothing. Dismissed. Yes.
But you can say it will not prejudice my future course of action, but you would say that.
What is it obviously will.
EPC prejudices, it will prejudice.
In the sense that
If it doesn't, we cannot create a new CPC under
In the
142.
sense, these matters
We
came
are
up.
not granting,
In the sense that it
we
came
are
up.
not
under-
granting liberty to file another suit. Then what is the matter?
The action.
What is the effect of 17.3? If we grant another liberty, ignoring CPC, then where the CPC will go? Order 2, Rule 2, 17.3, Section 11. Yes, next.
Appearing for the department, this
Yes.
is a statutory appeal. It raises two very important questions. The first issue is whether henna paste mixed with clove
This
oil.
is statutory appeal.
This is a statutory appeal, my lord.
It's a notice. It's a notice.
I'm obliged.
I am accepting notice in this matter, Your Lordship. I am appearing on caveat.
Yes. Third counsel, Mr. Chaudhary. Sunny.
Rupesh Kumar.
Rupesh Kumar.
Neelam Sharma A1.
You appear for the department or for the private respondent?
In this case, I am appearing for the respondent, Your Lordship. Caveat.
Accept notice. Rupesh Kumar. Post after 8 weeks. Yes.
Obliged.
Lordship, I have been led by Senior Advocate Rupesh Kumar.
The issue is already pending before my lords. Whether the currency can be seized under the GST provisions, Your Lordships. Even the office report also refers to two cases, Your Lordship. Anshul Jain and Gunjan Bindal.
Most obliged.
Yes, my lords. My lords, in this matter, there is a notification, basically an amendment was brought into 2006. In the notification of 2002, my lords, Himachal Pradesh VAT Act, my lords. Yes, my lords. My lords, they commenced protection in 2010. 31/3/2010. But my lords, that notification says, my lords, because there is a non-obstante clause also, my lords, and then there is an express provision. My lords, may please see the amendment notification, my lords, which is on, my lords, because if we are opening the, there is a new industrial establishment unit that is opening on 31/3/2010, as in the present case. The express provision says that the exemption shall be applicable only between 1 August 2006 to 31/3/2013. 2013. Now, my lords, the total exemption is for the period of 6 years and 8 months. But the legislative intent was to grant the exemption only up to 31/3/2013, my lords. Because if there is a non-obstante clause, my lords, it cannot override the express provision of law, my lords. But my lords, may please also. But my lords, if we see, my lords, clause 3 and clause 4, they need to be read together, my lords. It cannot be read and stand alone, my lords. My lord, may please see unexpired period.
My lords, a member of the force, my lord, that too, my lord, CISF. Now, my lord, my lords, he had gone to one BHMS doctor, BAMS doctor, my lords, and he had sent all sort of, my lord, incorrect thing, my lord, which was, and my lord, the High Court has literally reappraised the evidence, my lord. Now, my lord, your lordship will appreciate that the decision was based.
Where is that certificate?
Your lordship.
Where is medical certificate?
Medical certificate is, my lord.
You are promoting as central government, BAMS, all IUs and this. No. And now you say that BAMS certificate should not be.
No, my lord, so far as the certificate is concerned, my lord, now if he has any serious problem for which he was
qualified Ayurvedic doctor, why can't he issue
certificate? No, of course, my lord, no difficulty to that effect, my lord. But then on the face of it, my lord, when the my lord, officials of CISF, they considered his case, my lord, it was found that it was not correct.
Whether he was sent to medical board.
No, medical board.
After he joined,
Lordships, medical board he was not sent. Lordship may place it after vacation. I will
You could have informed him that present yourself before the medical board.
No, my lord, he came after long delay. That is
during pregnancy, when he applied for medical leave,
Lordship,
and you rejected his leave application, while rejecting,
he did not come. He did not come.
You should have informed him that please come and present yourself to the medical board.
Thrice we have given notice to him. Three opportunities.
Notice for presenting before the
Your
medical board.
lordship, thrice.
Where is that?
Yes. Now, my lord, if your lordship will kindly see,
Where is that?
thrice he was required to come, my lord. Annexure P3, my lord. P4. P5. P4 and P5.
Yes.
If your lordship will see, call up notice 22.5, then 27.5 and 9.6. So after having given him full opportunity, when he did not turn up,
you are.
Now, my lord, your lordship will see he's in disciplined force, my lord. Now, my lord,
we cannot say that you are avoiding our question. So what the question
no,
is?
my lord, so far as
you issued any notice calling him to present himself before the medical board, and you say, see the notice.
my lord, that specifically was not mentioned.
Then
that specifically that was
if
not
you
mentioned.
have any doubt that he is presenting false medical certificates or false application,
Lordships,
on leave on medical ground, I should have told him to present himself.
Now, my lord, if your lordship will see the findings, my lord, if your lordship will see at page, my lord,
post after PWD. Yes. As paid for them. As paid for them. Yes. Doodh wala.
Lord, the tribunal.
Similar matter is pending.
Lord, there is one matter pending. A bit, Lord, we are on a better footing actually.
Better footing?
Yes, Lord, I will point out that. Lord,
there is already an interim order.
Sorry, Lord.
Better interim order.
Yes, Lord. Lord, I will justify that, Lord.
No other interim order.
From that,
except that which is granted in the similar order.
No, Lord, may I just
realize that when we say it is pending notice issued, yet you are arguing, that means you want something better.
Yes, Lord, I said that. We are on a better
notice
footing.
tag with so and so, similar interim order.
Lord, in that case, one request, Lord. One request. Your Lordship may grant me time of 8 weeks to deposit because there is an order of interim order is stay subject to deposit.
Yes.
Lordship may grant me that time, my Lord.
2.02 crore.
No, in our case, 3 point something.
What is the amount? 3.5?
3.5 crores.
3.35.
3.35.
3.35.
Your Lordship may grant me 8 weeks so that, my Lord, I can make
amount है ये 2.02 के बदले 3.35 crore. Within a period of 6 weeks.
8 weeks, my Lord.
8 weeks.
Please.
Yes, 8 weeks.
I'm so glad.
Yes. Letter. Post of the PWD.
Lordship, letter has been circulated in this matter.
21 also letter, yes. Post.
Can it be listed after partial court working?
Yes.
Much obliged.
Yes.
Well, it's item 22 again is a statutory appeal under the service tax, and the issue relates to valuation, your lordships. Now,
yes,
in this case, what the under this appeal, what the assessee has done is they have provided certain services in the form of supplying men for the work of their client, your lordship. Now, for that purpose, they have received the gross amount. That gross amount includes their salary, their other statutory payments, as well as the service charges. The assessee has restricted the payment of service only to the service charges.
Notice.
Obliged.
Total tax effect is 14 crore. Something.
Yes, your lordship.
Yes. 10 weeks.
Lordship, we are still paying the interest. The interest is going post death also. So that is the only bone of contention. when the divorce has happened,
Divorce has happened and she is otherwise also entitled.
There's hardly anything.
3.5 lakhs only with interest.
but the interest, I mean, that is going post the divorce also. I mean,
Nothing. After hearing on counsel for the petitioner, we are not inclined to entertain the SLP accordingly. Dismissed.
Please, Lordship.
Yes.
Although being led by Senior Advocate Mr. Rajiv Bhalla Malad is online, but similar matters are already pending.
Yes, notice similar matters.
Please, Malad.
Check.
They are adjourned for 20th of August, Malad.
Yes. Permission.
Come along with that.
Yes.
Please, madam. Well, similar matter is always pending in the court.
Yes, Your Lordship. Item 25.
25. Which is that matter?
That's
Madam, this is Swatch Group India Private Limited. Diary number 8408.
8408.
Yes, Lordship.
By Chief Justice. Yes, issue notice, but their notice is issued on continuous bill. Same order karna.
Well, there is delay also 21 days.
Delay condoned issue notice tag with.
Oblige, Your Lordship.
May I please, Your Lordships, in item 26 minutes, civil proceeding, my lord, the suit for declaration, documents are filed 6 years after the written statement was filed.
Document, you filed document, counter document.
Minutes they have filed.
You may file document. What is this order 8 rule 1A?
No, minutes, it is the defendants who are filing additional documents.
Once it is allowed, submission of document. We never interfere under 136.
Minutes,
Dismissed.
If Your Lordships may just grant me 1 minute, minutes, the documents actually pertain to defendant number 1, and his evidence is already closed. And it is the other defendants who are bringing these documents. If Your Lordship may grant me the liberty of cross-examining defendant number 1 again, my lords, because his evidence is closed, my lords.
It is already granted to you.
No, my lords, that right is granted only to defendant number 3 to. My lords, that right is granted only to defendant number 3 to 5.
You may recall them on the basis of this document.
Your Lordship may just grant me that liberty, my lords. I'll be happy to take it, my lords.
If PC provides for that, move an application for that.
After hearing on counsel for the petitioner, we are not inclined to interfere with the order. However, petitioner would be at liberty to avail, would be at liberty to cross-examine the witnesses on the basis of newly introduced documents. And if the witnesses have been cross-examined, have already been cross-examined, comma, he may recall the witnesses, comma, if need so arises. Yes.
Deeply obliged. I'm so deeply obliged.
Yes, next.
Lordship, similar matters pending before the court. SLP Civil Diary number 1275, 2025.
Yes, 40712.
Yes.
And 29247. Yes.
1275.
Notice text. Delay condoned. Delay condoned. All matters.
My lords, may I mention one thing, my lords, in item 27, my lords. Item 27, my lords.
Yes.
I am appearing in item 27.4, my lords.
Yes.
On, my lords, 4th of March, my lord, a similar matter was placed before the bench of my lords, Justice Nagaratna, Justice Narasimha, and Justice M.M. Sundaresh. My lords, and there, my lords, notice was issued on the delay application as well, my lords. The delay was not condoned in that. That's the only thing which I want to inform.
Do you think it will be dismissed on the ground of delay when already noticed?
I just wanted to place the fact.
Batch of matters. Yes, next.
This is a difficult matter.
Dismissed on delay.
Yes, Your
Lord. After hearing on counsel for the petitioner, we are not inclined to, we are not satisfied with the reason satisfied with the explanation offered seeking condonation of delay of 751 days in referring the SLP. Accordingly, the SLP is dismissed.
Deeply applies.
Round of delay. Yes.
We are all employees of the High Court, retired employees of the High Court. There's a 29.
It is that period between.
Period. That's right, Milods. And this is a period when the PRC was
Apply to only those who have retired during this period of.
That's right.
1/7/2018 to 1/1/2020.
I'm grateful. And it creates a class within a class, Milods. Your lordships have
Notice,
repeated.
notice.
Obliged.
Yes, Mr. Naware.
View that the Honorable High Court has taken is, my lord, causing tremendous prejudice to me.
What prejudice?
I will
You
point out.
contested the election.
I'll point out.
Yes.
My lord, the limitation is 7 days. And that limitation is already over. High Court having entertained the petition and gone this far.
It is your mistake.
No, but
One certainly, it is not necessary that if we entertain, we have to grant you relief.
I don't say that.
Then.
But my lord, the High Court, while examining whether alternate remedy should be relegated, parties should be relegated for that or not, should also be conscious of the fact that today that alternate remedy doesn't exist.
If you choose a particular forum and prosecute the litigation, later on you cannot say the other litigation, if I would have chosen that way.
Would my lords have a look at the prayers in my writ petition?
Even otherwise, election luxury. Dismissed.
Please me.
31, Your Honor. Your Honor, despite filing my written statement within 120 days, the learned single judge denied taking it on a record, Your Honor. There is a specific observation also.
Notice.
Thanks. Your Honor, there is a stay application also.
Stay. Further proceeding before the trial court shall remain stay. Notice be made returnable within 8 weeks.
Your Honor, it is before the commercial bench of the High Court.
Huh?
It is before the commercial bench of the High Court.
Proceedings in the suit shall remain stay.
Yes. I do. Please, minutes. Because the land was allotted to me in 1994 and the amendment order was in 1998. But that amendment order was never served on me.
2003 it happened and you filed the writ petition in 2008.
In
You have not paid a single penny.
In 2003, the cancellation order, there was a recommendation made by the general manager.
It is available.
Come in a better case.
24, 30 years, more than 30 years, dismissed.
Published.
Registrar of companies, yes, rightly quest.
Here, similar matters are pending, The
Lord, I'm sorry.
Similar matters which are pending.
Dismissed by this court, Lord, NBC. My learned friend should point out, Lord.
But there are two kinds of
looking at
orders,
the similar matters, we are not inclined.
There are two kinds of orders. One order where your lordships have entertained SLPs, and there is one what my learned friend is indicating.
9th May, Lord, my learned friend knows 1st May they got an order expiring. 9th May this court delay. See the delay, Lord. 1,000 days. 1,000 days.
How much is the delay?
1,060, 1,094, Lord. And that case was 1,071, not 1,094 days.
1,094 days.
Yes, Lord. 1,094 days. In this case, Lord. 1094, Lord. Page 434, you'll get it. 1094. And this is a not order. There were 11 SLPs. This is similar order. Not 2 SLPs were discussed that day. My learned friend has not placed this order on 9th May on record. It was their duty to place it. And they made another mistake, suppression note. They got opportunity to file counter. Matter came out after 5 months. Then the matter was decided. We had those orders also. They made a wrong statement that they didn't get a chance to file a counter, or the court has acted with haste.
Yes,
Mr. Joshi, there is nothing. We have dismissed 1093 days matter.
Yes.
Now this is 1094, 1 day extra.
Yes.
And each day delay has to be explained. So if you cannot explain 1093,
I can't run away from the fact there is a delay, Yes, I can't run away from the fact there is a delay, Otherwise, on the main issue, there was one SLP in Kapil properties where notices were issued.
Barred by 1094 days. Full stop. In a similar SLP, challenging the common judgment, it is common. Challenging
No,
the,
No.
challenging a similar
But
judgment.
batch of matters, that's it.
Similar judgment
Similar judgment.
by the same High Court has been dismissed on the ground of delay, leaving the question of law open. The said order in SLP criminal number 12506 of 25
And diary number 12507, madam.
and diary number 12507 of 25 is placed before us. Full stop. Madam. Considering the above, as also for the reason that we have independently examined the ground mentioned seeking condonation of delay, and we are not satisfied that the petitioner has been able to explain each day's delay in filing the SLP. Accordingly, the IA number 74 seeking
condition for granting parole for getting treatment, they are the first.
How can we grant parole when it is reviewed by the authority and by the High Court?
My lord, they are
How
for,
can we grant
they are for your lordship, I am before
We
your
are not
lordship.
parole granting authority sitting here.
Your lordship, the parole granting authority is the superintendent, but it
You have
was,
not
it
completed
was.
5 years.
Your,
You have not completed 5 years
No,
after
we
commission of
already-
the latest
we are-
offense. That is the
earlier-
law.
my lord, earlier we had granted parole and we have completed more than 5 years. My lord, we already granted parole in this matter, my lord.
Yes. Move again if you have been granted. Next.
My lord, kindly see the order is there, my lord.
There is nothing.
My lord, that is the parole for the medical treatment of my father, my.
Yes, yes, next.
My lord, kindly see the page
We have
55.
seen, there is nothing in the matter. Yes.
For the parole, we don't suppose for any merit to be seen, my lord. It is
No, no,
only
we
for
haven't
it.
seen the
Merits of the SLP, not the parole.
Merits of the SLP we have seen.
Yes, next. You have done your best. Yes.
Balance in it's settled that in a criminal trial, each accused has the right to delete defense evidence merely because two co-accused have examined 4 witnesses, defense witnesses. That's no ground to
You have already examined 4.
No, that's the other 2 accused. That's the misnomer. I have not been able to examine any. And my application was filed in March 22. There is no delay on my count. Delay is by the complainant when defense witness starts. He says, I must cross-examine and not the APP. He goes to the High Court. 2016, the trial is stayed till 2019 after he dies.
Notice returnable in 4 weeks.
Malad, in the meantime, final judgment be not passed by the trial.
It is for final judgment.
It's not listed for
Then we
final
are not
judgment.
notice.
No, then we are not.
No, it's not listed, but maybe because of the pendant. Very well, Balance.
There is no stay. Yes.
Returnable.
Returnable in 4 weeks.
4 weeks. Deeply obliged. That's
In 36 plots, I'm humbly representing the petitioner, lords, who is a colorblind candidate, lords.
What
He-
candidate? Colorblind.
candidate.
Yes.
That was the only disability lords he was having, so-called disability lords. This honorable court lords and various judgments lord, which I have annexed in my compilation, which I'll be submitting for this honorable court, has laid down lord
There
that.
is an order that it should be placed before Honorable Gavai here.
Please lord.
That this order 15-1-2025 says list before a bench presided over by Honorable Gavai.
Please lords. As lords, honorable lords, Chief Justice of the lords.
In view of order dated 15-1-2025, post after PWD.
I'm so
Yes.
Okay.
Written notes. Lord, in this case, my learned friend has approached me. We've been talking in the week. She wants a week's time to come back with an alternate proposal. We're trying to find a closure.
There is some ray of hope, it seems.
We are hoping. but
We
my
are
learned
trying,
friend has
Manoj.
been
We're
very
trying
kind,
our
Lord.
best.
She's
All
been
the
very clear and
limitations we go away.
Parties who submit that negotiations are still going on. Negotiation or deliberations?
Deliberation. Deliberations is better.
That deliberation for settlement is still going on. Post
Next Friday, Lord. I think it'll take a week.
next Friday it will happen.
That's what my learned friend indicated. A week's time she wanted. If it
Honestly, my lords, my client said that take a
Some
little
more
bit
time.
more, some more time. Yeah.
Then have it Monday thereafter. Not that's the Monday the 16th.
16th.
16, I'm not in town, my lord, so that's the difficulty.
18th.
18th.
That's very well. 18 is fine.
18th.
Great.
18th. Next.
My lords, last week, your lordship.
Your Lordship, Ms. Vanchaja Shukla, standing counsel, appears in the matter. She's not in India, Your Lordship, so, and we have not been issued wakalatnama in the matter by the state.
My lords, this is a contempt. Your lordships had issued notice last week, returnable in a week. This is the 5th occasion in which the state has disobeyed, my lords. My Lord Justice Mishra, sitting with the Chief Justice, had issued an order clarifying and then reiterating the clarification that we petitioners were eligible to be appointed and should be appointed. Despite that, my lords, we don't even get called for multiple rounds of counseling. Now candidates below us are being called for counseling. There were 279 vacancies. We are 239 petitioners. We are before my lords, and they are moving to finish off all the vacancies and be in contempt of my lords.
When do you want?
Your Lordship may keep the matter after 2 weeks or in July.
After 2
before
days.
the,
Choose your date.
Your Lordship, any date after 2 weeks is fine. We'll file a reply.
Any date after 2 weeks.
We will be permitted to file a reply.
My lords, would your lordships
Wait,
consider?
just here.
Yes, my lords.
As prayed. Today is 6th, no? 16th. Post on 20th June. First up, the contenders shall remain in attendance before this court on the next date of hearing.
Your Lordship, just one submission, what ma'am has suggested.
No, we are granting time.
The only
Right
one
for
suggestion.
granting time.
In these 239 petitioners, applicants also, few have already got joining letters. That are the instructions. And we are collating.
Contempt will remain for those who have not been.
And Your Lordship, the order of the Chief Justice, the order is very clear. If the applicants are found to be eligible, then they will be considered.
No,
so there is no.
No, that they are not eligible.
There is a particular caveat saying that if they are eligible, they'll be considered. So
This-
all the petitioners
this
are eligible.
counsel,
It's not a correct
either you are
submission.
ready or not ready.
Your Lordship, these are the.
Don't argue after having sought adjournment that you are not ready.
Your Lordship,
Don't
you have
argue.
authority to appear only because.
If you argue, we will pass order today itself.
No, Your Lordship.
Finally booking you
Your Lordship may keep the matter
and
on
putting
20th
you
June.
at the right place.
No, Your Lordship may keep the matter on 20th June. We'll file a reply.
Yes.
Only
And
because
keep
the
them-
submission was made.
keep all the contenders present.
Very well, Your Lordship.
I'm very grateful, my
Yes, next. Yes.
Lordship, in accordance with the last order, FIR has been filed. Lord, this is a transfer petition seeking transfer from Kanwar district, Karnataka to Faridabad, Haryana. What is the distance between the said two places is around 2,000 kilometers. And
for a minute, Manoj. Manoj, this is the date of Manoj. So, Manoj, my father was admitted in a hospital in Delhi. I decide to go meet my father in the hospital. It does not bear well with my deceased wife. Please see at the bottom of 141, Manoj. This is a message on the date that I'm sending to her. जाना कल रात को मैंने क्लियर बताने की कोशिश की थी
141.
I'm so sorry, Manoj. Numbered page 141.
Yes.
Yes, Manoj. Towards the bottom of the page, your lordship will find from a message. No, this is a part, Manoj, was filed by the state itself. जाना कल रात को मैंने clearly बताने की, this is me writing to her. कोशिश की थी कि जब बताया था कि आज उनका ऑपरेशन है पर आपको अच्छा नहीं लग रहा था इसलिए नहीं बता पाया पर मेरी बात समझे ज्यादा खुल के भी तभी Manoj, just allow me 2 minutes. Manoj, just allow me 2 minutes. Manoj, there is not a whisper of an allegation of any Manoj dowry any time prior to that. There is no contemporaneous record of any allegation. There is a 3-1 remote allegation made Manoj, some exchange of 40,000 rupees between the daughter and the brother. There is nothing other than that.
Next.
Short and limited prayer.
Yes.
That the complainant lodges the complaint under section 354. Thereafter, subsequently 5 days, rape charges.
But the impugned order,
impugned order.
application for preponement of hearing of the bail petition has been dismissed. We are not inclined to entertain the
And only very short prayer that many complainant
With cost
manipulate
of
proved
rupees
it.
1 lakh. With cost of
Kindly have
rupees
1 page,
lakh.
only 1
With
page.
cost of rupees 1 lakh.
Sorry.
Is this really because Delhi is here, the Supreme Court is here?
2 months time has been
What
given.
2 months time? You bring everything to Supreme Court.
Jana, she takes the time by the High Court by saying that I
Yes,
need
next.
to appear in person.
Next.
And it's only cost for you.
Costly. No cost. Yes.
Well, this is the
Is it infractions?
I'm sorry, my lord.
This is infructuous, this 42.
No, your lordship, they have filed the IE for my application for extension of time in terms of your lordship's order of 30th of May. My lord, this is concerns, my lord, the NEET PG.
Yes, NEET PG.
My lord, the exam was to be held on the 15th of June.
30th of May.
On the 30th of May, your lordship corrected that the exam will be held in a single shift.
Yes.
And your lordship said that we should try and do it by the 15th of June. But if we cannot, we should come back to your lordship for extension of time. Lord, by this application, we have come to your lordship for extension of time to hold the exam on the 3rd of August. That's the sum and substance of our application, Lord. That's basically what it is. In the application, my lord, we've highlighted the difficulties that are there and the steps that need to be taken for the purpose of that examination. Lord, the total strength of the candidature is about 2,50,000.
Where is this?
2,50,000, my lord. And my lord, the centers that were there when we were holding it in 2 shifts were around 450 centers. Now, my lord, since we are supposed to hold it in 1 shift, my lord, we need about 450 more centers, around 500 more centers. So that's about 1,000 odd centers that will be required. Identification of those centers to ensure that those centers meet the security parameters. After the centers are shortlisted, giving the students a fresh opportunity, my lord, of choosing their test cities and thereafter allocating centers will take a little time, my lord. We've sketched out that, my lord, in our application. So all that we want from your lordship, my lord, is permission to hold the exam not on the 15th of June, but on the 3rd of June. That's basically what it is, my lord. If your lordship wants, I can show to your lordship, my lord, from the application, the various factors, my lord, starting in paragraph 3.
Take.
My lord, I appear, sorry.
Today is 6th June.
That's right.
You want time till August.
3rd of August, my lord. Till the 3rd of August.
Yes.
My lord, please.
Why so much of?
So, my lord, may I just explain? Basically,
you only have to identify and you haven't started the process as of now.
my lord,
That order was passed last week.
30th of June, my lord.
Yes.
30th of May, I'm sorry.
That's right.
My lord, we
So
have to
how much time has gone by? What exercise have you done?
My lord,
You're delaying. That's what it is.
my lord, I'm sorry, my lord.
2 months you want for this only.
My lord, may I just explain? If your
All
lordship will
the
take,
things are required.
Only centers are to be located.
my lord, after the centers are located, then the students have to be given a fresh opportunity. But at the same time, a fresh opportunity to opt for test cities. My lord, so therefore, just to explain, my lord, if your lordship will take my application, I'll just explain that. Your lordship will take my application.
Oh, that's right. But the time we are concerned about.
My lord, I
Understandable that maybe 3 weeks.
Entire June, entire
everything
July.
will be. My lord, may I explain that?
Process
My lord, may I explain that? My lord, the TCS, my lord, they are here, right here, which are in front of your lordships. Once a center is identified, my lord, there are quite a few things that have to be identified in the center.
Unfortunately for you, we
Yes.
know that how the TCS works. There is no problem as far as that is concerned. The thing is, the period which you are asking is too long a period. The whole process will be delayed, the selection process, everything. Children are studying, it's an added pressure on them, the time frame.
My lord, the internal.
Shorten the
Just 1
time,
minute, please.
shorten the time, shorten the time. We will be granting you time.
My
We
lord,
have no issues on that.
I understand, my lord, but your lordship will only understand the difficulty, my lord. May I just explain that? My lord, as on date, we have about 450 centers that we've identified. When
No
we-
issue on that, we know that.
We have to extend that, we have to double the centers. As far as the centers are concerned, my lord, once we do that, we have to ensure that the centers are all safe. Safe, my lord, technologically compliant, and my lord, they meet all the manpower requirements. That in itself will take some time. Once that is done, my lord, in terms of the brochure, the students have to be informed at least 2 months in advance.
Correct, you're right.
My lord, we would not ask for your lordships any extra time apart from the time that is actually necessary. We would not trouble your lordships with that. There is a safety and there is an integrity of the examination that I must ultimately, my lord, I'm so sorry. My lord, I'm appearing for the NB, my lord, the union is represented by by the ASD, I think. But TCS is not a party, my lord, but they're here. That's
Therefore, give us time till 3rd August.
No, no, I'm
Among
sorry.
all other
If
grounds.
your lordship will take the letter, we've explained that there are some exams that are to take place.
After explaining everything.
Yes.
If you come to page 28.
Yes, 28.
that is letter of TCS.
Yes.
saying that
Yes.
Aside, we are conducting examinations for Indian Railway banking exam, many regional, so and so across the country. Hence, we propose to conduct this exam on 3rd of August.
Well, in the sense that there are other exams also being conducted. In fact, my instructions are some exams have actually been postponed.
But there is
for
a
this
difference
purpose.
between this exam and other exam. There is no curriculum like in other exam. They are competitive exam, but the NEET PG is a curriculum exam.
Well, as far as this is
Everything will be
concerned-
delayed.
No, that's
And the difficulty which is being faced.
My friend can't have an issue. Ultimately, my lord, it's a question of the.
Lordship, they have all the mechanism. TCS has 60,000 centers.
Time before 3rd of August.
My lord, the TCS is here, my lord. Your lordship, my lord, we've discussed this thread where it's very difficult, my lord, to find centers and identify them, make sure that they are technologically, my lord, sound and safe.
Let's put it to you.
Yes,
straight.
sir. Yes. Sir.
TCS is into the whole process of selections only.
I'm sorry, my lord.
They are in the process of selections.
Yes, my lord.
They know each and every center.
Yes, your lordship.
They are aware of which centers are compliant and which are not. There is no fresh exercise to be done.
There is, my lord.
The only thing which is to be done is the availability of those centers. That's the only thing which is required to be done.
May I should.
They are aware of it because they are conducting all these exams.
My lord, if your lordship will just take, for example, I'm so sorry, my lord. Your lordship will just take the letter that your lordship just referred to. Please see, for example, my lord, apart from the identification of centers, we need to identify. I'm so sorry.
Lordships.
My lord, we have sketched out, my lord, the various steps that have to be taken.
Somewhere in July, 2nd, 3rd week of July.
My lord, the learned AST wanted to say something. I think he needs to be unmuted. So sorry. He's appearing for the union. My lord, if your lordship will take this chart, we just sketched out, my lord, the various steps that need to be taken in the identification of centers.
Am I audible?
Yes, my lord. Yes.
I'm sorry, I was not unmuted, so I could not say anything.
My lord, we've tried to do all that we can.
Am I audible?
Yes.
Yes. I'm told there are practical difficulties. Actually, a high-level meeting was held couple of times. Because now what has to be done is the centers will have to be doubled. I mean, it has to be doubled. Earlier,
That's right.
500, now it has to be doubled. Now there we have to make some security arrangements also because it's all India one-time examination. That is the only concern. Therefore, if there is any smallest minute breach of either any kind of leakage of question paper or any kind of breach,
No,
it will
these preparations have to be made whenever the exam takes place. It is 3rd August or 6th June or 18th July.
That's right, your lordships
This
are right.
security, these steps have to be made anytime.
So those preparations were made
From
for.
15th June, these securities have to be made.
Yes, but that was made for
There's nothing
450
new
centers.
that because we have directed examination to be taken in one shift, you are to do all this.
Well, your lordship is absolutely right. These preparations were made for 450 centers. Now we have to make them for 900 centers.
TCS on its own website, they have published that they have more than 60,000 centers equipped, well equipped.
No, my lord, this is actually an online examination.
Yeah.
So
So what security?
There are, as far as online examination, the systems have to be secure. Not just, my lord, security in terms of physical security, but in terms of security as far as online examinations are concerned.
What security?
Server requirement.
Some command.
My lord,
Some command in the computer.
Not
that is the security.
Not just that.
Some firewall to be installed.
That the systems have the software in which the exam can be taken, and the exam is sealed otherwise. My lord, some of these
all excuses. I don't know why you want such a long time.
TCS claims that they have more than 60,000 centers.
My friend today is.
No, sir.
If tomorrow something happens, my lord, ultimately the guns will be pointed at us.
Obviously, also.
That's right.
They are conducting the exam now. They will come up with the excuse.
We don't wish at all for my lord the exam.
Today this excuse, tomorrow that some other excuse.
We don't wish the exam to be compromised in any way. That's all, my lord. That's
So
all.
we would also not want that.
That's
Last year they did it.
We are, my lord,
Last thing we should have.
that's right. My lord, so therefore, that's the reason why we are saying, my lord, even if there is some, my lord, time span being taken, it is only for the purpose of the benefit of the students, so that no questions are asked.
May make a small suggestion?
Yes.
Yes. Kindly have it tomorrow. I'll have one more round of litigation. If you can reduce.
Tomorrow we are not working.
Yes. If you can have it early, definitely I will have one more round of exercise about it, discuss it, and get back by tomorrow. So we'll have better discussion, and if possible, we'll try to advance it.
Your Lordship, if I may submit, Your Lordship, TCS on their website have mentioned that they have
Student no role to play in this matter. Unnecessary student need not be heard in this matter.
I humbly request, sir, please let me submit.
Let them hold on the third.
We have a sufficient number of cities.
One more request, Lordship, that the delay which is being made by the respondent, they should consider the internship period, Lordship, because other students are being affected because of this curriculum. So that should be considered by the respondent. That's all.
Other students?
Like internship period will be, there is fixed internship period.
No, there's nothing like that.
There will be problem with every day.
Every day.
Whether it is the 15th of June or 3rd of
August, there will be some issue.
Some person will always have some problem.
Yes. Please have it. Please tomorrow. I'll have one more round of meeting, and I'll get back by tomorrow. Please have it tomorrow.
No, we are disposing of allowing you time till 3rd of August.
Very well.
We are allowing you right.
Very well. I'm grateful.
If a submission can be made regarding the internship period, Your Lordship, if examination will be.
We are only considering this IA.
Your Lordship, I am requesting for an additional relaxation on the internship period time. That's it, Your Lordship. I am obliging by what Your Lordship says.
That is rejected. IA number so and so has been preferred by the respondent.
Or the National Board of Examinations.
National Board of Examination in Medical Sciences.
That's right.
Seeking
rescheduling of the date.
Seeking reschedulement of the NEET PG 2025 examination on 3rd of August 2025, which according to the respondent is the earliest possible available date given by its technology partner, that is TCS. A reference is made to various communications between the respondent number 1 and the TCS, highlighting the preparatory paraphernalia to be developed for conduct of examination. Full stop. Having gone through the papers annexed with the IA, we are satisfied that the prayer for extension of time to hold the examinations, rescheduling it on 3rd of August 2025 is bona fide. Full stop. Accordingly, the time allowed by our order dated 30th May 2025 for holding NEET PG 2025 examination is extended, and the respondent number 1 is permitted to hold the examination on 3rd August 2025. It is made clear that no further extensions shall be granted. Yes. Next.
Seeking permission to file a hard copy of the appearance, Lordship, because I have a connected matter.
Yes. वो उनका ASG का भी अपडेट डाल दूँ.
Oblige, Your Lordship.
Only IC. Yes.
Battery for 15 July.
नहीं वो तो जब वो मेंशन करेंगे तब लिस्ट होगा. कुछ नहीं वो तो इंफ्रास्ट्रक्चर हो चुका है वो. भी इंफ्रास्ट्रक्चर इन्हें देखो लगी 15 जुलाई के आपने.
May it please, I beg to appeal for the 43. I beg to appeal for the bank, Milords. The impugned order binds.
What remains in OTS?
No, there is.
You are concerned with your money.
There's something very serious, Milords.
Whether it is by the High Court or by the Supreme or by the
under the OTS, Milords, I'm entitled to 3.82 crores. The impugned order gives me an amount of only 4 lakhs above the 90 lakhs that was paid. So that is the first and foremost, Milords. There's a vast difference between what I'm entitled and what the impugned order gives. That is the point number one.
Notice.
Great. Because they just stay on the operation because they are asking for the documents back, the title deed.
Yes, stay.
Stay. Great, deeply great.
My lord, I am appearing as
Yes,
petitioner.
stay of the impugned order. Yes.
I am appearing as petitioner in person for serial number 44. Today it is listed for condonation of delay. My lord, in fact, there is no delay since the previous SLP which I have filed.
This is also infructuous.
Why, my lord?
Why? You have already appeared in that examination.
Yes, my lord, may I just explain for 1 minute what is the issue? My EWS rank was 134. I am an EWS candidate. My rank was 134.
But there was no EWS seat.
My lord, may I just show the judgment of
In the absence of any seat or EWS, what is the use of that rank?
My lord, since last 6 years, EWS reservation is not implemented in private colleges. I am just quoting the judgment of the Supreme Court.
You should have applied for it before the examination.
I have applied for it, my lord.
Applied means applied by filing a writ before examination. You have filed the writ petition after the examination was over.
But my lord, it was not my responsibility to file a writ
No,
petition.
it is your responsibility to file a writ petition.
I am not the only person.
You are claiming some relief,
Yes,
knowing fully well
Definitely.
that there is no seat earmarked for EWS.
But
it is your duty.
My lord, how would I know that EWS reservation is not there in private colleges? Since SC, ST, OBC, EWS.
There in the brochure.
No, my lord, it was only written in the Gazette notification of Madhya Pradesh, which contain all the rules since 2018. How would I know that there is a provision which says that EWS reservation would not be there? I am just reading Janit Abhiyan versus Union of India. It was the constitutional bench, and it says, my lord, page 135, my lord. That is my written submission.
Yes.
My lord, kindly turn to page 135. It is the case of Janit Abhiyan versus Union of India, and that was a constitutional bench.
You apply it after when the next examination takes place.
My lord, I have already appeared for.
We will give you liberty.
My lord, I have already appeared for NEET 2025. It was on 4th May. I am just reading, my lord.
That examination is also over.
Yes, but my lord, counseling is not started.
We cannot provide seats after the counseling.
High
Seats are
Court has-
already fixed.
My lord,
When the examination is taken place.
High Court has ordered to implement EWS reservation by increasing.
We are not in time. We are not in. Considering that.
My lord, just 1 minute, my lord.
2024.
My lord, the constitutional bench says that EWS reservation has to be implemented in private colleges.
Is already over, and even NEET 2025 has already taken place. We are not inclined to
My lord, just give me 2 minutes.
this SLP. However, the petitioner would be at liberty to move afresh in the ensuing NEET examination for the year 2026.
My lord, this is not correct, my lord. EWS reservation was implemented 6 years ago. I am just reading 103rd amendment. What does it say? Any special provision for the advancement of any EWS citizen other than the classes mentioned in clause 4 and 5, as insofar such provision relate to their admission in education institution, including private education institution, they are bad to provide. They are compelled to provide EWS reservation. I am just reading what Janit Abhiyan says. Just 2 minutes, my lord. Not more than that. Para 138. No better articulation than the aforementioned is warranted to hold the EWS reservation equally applicable to unaided private institutions. This is the judge. There are several judgments of the Supreme Court to implement EWS reservation in private colleges.
Yes.
My lord, since the